Dear students, my name is Udara Soy, at Law. I've been helping students with the University of London programs for nearly a decade now. I'm so blessed to be giving this knowledge to you, and I hope you can use it for exam. So make sure you read your textbook, make sure you read your subject guide, make sure you do at least 100 past papers per subject. So in this series of presentations, I will try to break down several areas such as equity and trust, public international law, and also there are some great aspects you need to focus in terms of commercial law. So administrative law. Administrative law is one of the most straightforward areas for exam. Again, the starting point is to understand that administrative law is somewhat a part of constitutional law. Administrative law focus on the relationship between people and public bodies. The entire focus of your syllabus, I would say 90% focus of your syllabus is with judicial review. Remember, judicial review is not available as of right. One must come with clean hands for a judicial review claim. You need to have not only a legal case but also a moral case and must fall within the time limits with proper locus standi. You need to have a legal standing prior putting an administrative case for judicial review. There are 3 grounds of judicial review you need to focus as per the case of GCHQ. Law diplock, illegality, irrationality and proceeding impropriety. Illegality, irrationality and proceeding impropriety with the upcoming ground of proportionality. When you look at illegality, there are errors of law, acting without power, unauthorized delegation, improper purpose. When you look at irrationality, you should link it with, again, Wainsbury unreasonableness with the Wainsbury case, and then you should compare it with proportionality. Is irrationality relevant anymore after proportionality, especially after Human Rights Act? For proceeding impropriety, there are several points, sub-points in reality. Rules of natural justice, legitimate expectations, as well as statutory procedures. Finally, to put a case for judicial review, you need to have a locus standi. And as per the case of O'Reilly versus Macman, public law matters needs to go through judicial review process. Again, as per your syllabus, there is an alternative to judicial review. You can go to ombudsman. So ombudsman is a great area. I'm going to make these ombudsman notes available on my website soon. So ombudsman is a great question for your May exam if you are able to focus. So here are my examination areas. You should also focus on Human Rights Act. Human Rights Act has a dramatic and a drastic impact on judicial review and administrative law. So you need to focus, what are these impact? What was the impact? What are the proportionality points? How was the law before Human Rights Act? So your exam areas, in my view, Human Rights Act, proportionality with Wainsbury and GCHQ rationality, ombudsman, O'Reilly versus Macman, locus standi, a great focus on the problem question on illegality. I would really suggest you to focus on natural justice. It's quite easy, quite straightforward. I'm going to make my notes available to you, and then again with a good focus on legitimate expectation, linking the substantive legitimate expectation with estoppel. So usually examination will focus on, again, you need to compare with estoppel with SLE. So this is a very brief outlook, a brief and a fast outlook. I hope you enjoy, I hope you learn. Again, people will keep replaying until this gets into your heads. I'm going to make these charts available to you. Thank you so much.